This is Michael Popok, Legal AF. Let me lead off with a quote from a new letter prepared by leaders of the House addressed to Clarence Thomas, encouraging Clarence Thomas to abide by the new code of conduct of the Supreme Court and step off the bench on anything related to Donald Trump, and especially those cases like Colorado coming up before him now on appeal as to whether Donald Trump should be on the ballot or not. And this is how the letter ends. I'm going to start my hot take with it. Quote, fewer than half of all Americans trust the Supreme Court, and that number will fall even lower if you, Clarence Thomas, rule in this case. That's how the letter ends. I'm going to talk to you about where we are with it, why it's so important for us to shine a Klieg light on Clarence Thomas and his being ethically challenged and compromised, and how that impacts our justice system. There's no other way to put this. The relationship between Clarence Thomas and his wife, Ginny Thomas, a wife of 36 years, is such that the household of the Thomases is financially benefiting from her close relationship with Donald Trump, from her leading MAGA right-wing not-for-profit consultancies and other organizations to support Donald Trump's legal and political and policy decisions. She made tons of money for her and for her husband when Donald Trump was in office. She is incentivized to try to get him back into office in order to help the family financially. That alone is a disqualifying event for Clarence Thomas, that he's going to benefit from some business at the court. And you also have the fact that Ginny Thomas is not just an accidental witness to the Jan 6th insurrection. She was the party planner and wedding planner. She was the organizer for bringing people to the Capitol that ultimately led to the riots that were encouraged by Donald Trump. Right? Her foundations raised money to bus people in to participate in what became the insurrection. So she's not just a passive drive-by, hey, I wonder what's going on over there on the mall. She knows what was going on in the mall. And then leading up to Jan 6th, she, from the day after the election all the way up to right before Jan 6th, she was a fervent supporter of Donald Trump and trying to promote the Stop the Steal arguments, texting incessantly Mark Meadows, the chief of staff, now an indicted co-conspirator, to get him to overturn the will of the people. Election officials and elected officials, dozens and dozens of text messages have been revealed by Ginny Thomas. And she testified to the Jan 6 committee. The report of the Jan 6 committee, all 300 and something pages, is the foundational evidence for both the Secretary of State and the Colorado Supreme Court justices, ultimately through the trial court level, the basis to find that Donald Trump was an insurrectionist and or committed rebellion against the Constitution, leading to him being banned on the 14th Amendment, Article 3. She testified. No, she testified. She tried to remove Liz Cheney and Adam Kinzinger from being on the panel at the early stages. So Ginny Thomas, who's benefiting financially, therefore Clarence Thomas is benefiting financially, who was a witness related to Donald Trump's insurrectionist and rebellious behavior, who was the party planner, wedding planner, if you will, for Jan 6th, right? And the Jan 6 report being this important of a piece of evidence that's being used by judges and by Secretary of States to ban Donald Trump. How can Clarence Thomas even think that he could satisfy the conditions of the new code of conduct that the Supreme Court just passed, but is self-policing? Not only self-policing, each justice has to make the decision for themselves. There's no motion to disqualify that we can file. Some people might be thinking, why didn't they file a motion to disqualify like at the trial court level? Because there is no equivalent at the United States Supreme Court level, because they didn't adopt a policing mechanism within their own code of conduct to let litigants, let alone average citizens, move to disqualify a justice. It's up to the justice's own conscience to make the decision whether the factors apply and he should be disqualified or accuse himself. Good luck. But what do we have? We got a new letter that's right from senior leaders of the Democratic Party in the House, led by Hank Johnson. These are all Congress people. AOC, Dan Goldman, who's one of the managers of Donald Trump's impeachment, along with several others who have written a very strong and pointed letter, not to Clarence Thomas's boss, not to John Roberts, the Chief Justice, but right to Clarence Thomas, Associate Justice. And here's what it says. I'm going to read you the really important parts. Dear Justice Thomas, on December 15, 2023, we wrote imploring that you recuse yourself, that means step off the bench, from any participation in the case of U.S. versus Trump. That's the main underlying Jack Smith special counsel case in the District of Columbia, given your wife's intimate involvement in Mr. Trump's alleged efforts to overturn the 2020 election. More particularly, they referred to Ginny Thomas's substantial involvement in the events leading up to Jan 6 insurrection and the financial incentive it presents to your household if Trump is reelected, all of these things being disqualifying. They then walk through the actual code of conduct that we're now waiting around for Clarence Thomas to decide whether it applies to him or not. In Canon 3B, that provision of the code of conduct, it states that, quote, a justice should disqualify himself or herself in a proceeding in which the justice's impartiality might be reasonably questioned, where an unbiased and reasonable person who is aware of all relevant circumstances would doubt that the justice could fairly discharge his or her duties. The code details such instances, including those in which the justice knows that the justice or the justice's spouse has a financial interest in the subject matter in controversy or in a party to the proceeding, Trump, or any other interest that could be affected substantially by the outcome of the proceeding. And that's the framework. And then they go off and tell Clarence Thomas exactly how those factors here have been implicated, and he should disqualify himself. So they start with her testimony before the Jan 6 committee, just to remind everybody, or those that didn't know. When Ginny Thomas was summoned to testify before the House Jan 6 committee, your wife told the committee, this is the letter back to Thomas, that she attended the Jan 6 Stop the Steal rally where Mr. Trump ginned up the attendees into a mob, whipped them up. But what she left out is that she was instrumental in planning it, bringing the insurrectionists to the Capitol. Your wife was one of 9 board members for a conservative political group that helped lead the Stop the Steal movement, a movement which culminated in the Jan 6 attack that the Colorado Supreme Court deemed an insurrection. It is unthinkable. It is unthinkable that you could be impartial in deciding whether an event your wife personally organized qualifies as an insurrection that would prevent someone from holding the office of president. Just think about that for a minute. She not only organized it, she was paid to organize it. So there's part of the financial incentive that we talked about. She's not just a witness to the Jan 6 rally or on the ellipse. She organized it. And then it goes on to say on page 2 of the letter, furthermore, your wife of 36 years, Miss Thomas, has shown a fervent interest in or bias in favor of Mr. Trump. She urged Mr. Trump's chief of staff, the indicted Mark Meadows, to pursue unrelenting efforts to overturn the 2020 presidential election, with dozens of text messages starting immediately after Election Day and ending only days after the Jan 6 attack on the U.S. Capitol, not before. She's still texting him after the insurrection. She also signed a letter urging then Minority Leader McCarthy to remove Adam Kinzinger and Liz Cheney from the Jan 6 committee that is the foundational basis of having Donald Trump removed from the ballot. Ms. Thomas was a witness due to her intimate involvement, and that committee's report is integral to the case. And now they hit Clarence and Ginny Thomas where they live, in their pocketbook. This is the same group of people that have taken millions of dollars of lavish trips from right-wing MAGA extremists who have business before the court, who have sold and participated in real estate transactions with right-wing MAGA people or people who have business before the court, who have accepted gifts of tuition for nephews from people who have business before the court, or have filed amicus or friends of the court brief, or actually are litigants before the court. So they've never seen a financial incentive that they haven't ignored. They've never seen one that was worth disqualifying them. And since the Supreme Court, back where the Code of Conduct, has made this self-policing, there is no way to file a motion to disqualify or recuse a United States Supreme Court member. You can at the trial court level. There is a process for the litigants, the parties, based on the facts and the law, to disqualify a trial judge. You can't do it at the Supreme Court level. Even the Chief Justice Roberts, can't go to Clarence Thomas and tap him on the shoulder and say, "You're out, Clarence. We're going with 8 on this one. Your code of conduct has been violated." We have to leave it to the person who actually is the person charged with violating the code of conduct to decide whether he has violated the code of conduct. How ludicrous. It's not even self-policing. It's justice by justice policing with no alternative or appeal process. So they hit him where they live financially. Finally, it is foreseeable on the bottom of page 2 of the letter that your wife's earning capacity will be positively impacted should the court grant the relief sought by the former president. In other words, put him back on the ballot and help him become president again. They then outline that before Trump was president, her consultancy at an entity called Liberty Consulting made up to less than $15,000. After he was elected, to try to file briefs and do lobbying to help his Trump's policies like the Muslim ban and things related to COVID, it skyrocketed to up to $250,000. Ms. Thomas's professional and financial interests, the letter goes on to say, are aligned with Mr. Trump becoming president again. And should he be reelected, it is likely that your wife's income will be favorably impacted. Your wife's income benefits your household. Therefore, your family, and by extension, you personally, you, Clarence Thomas, have a financial stake in the outcome of this case, which disqualifies you from any involvement in it. To protect, this is how the letter ends, to protect the court's integrity, whatever's left of it, and the legitimacy of its decision in this monumental case, you, sir, must recuse yourself. Now we'll have to sit back and watch. It's up to Clarence Thomas again. It can only be where we do a pressure campaign as led by the Democrats in the House and the Senate and by the MeidasTouch Network and on Legal AF, where we shine the Klieg light on it and we don't let up with attention or pressure until he relents. And if he doesn't relent, then we can call out the United States Supreme Court and for the illegitimate process by which they rendered their decisions related to Donald Trump. Can't ignore it. They want to bury their heads in the sand. We can't. We don't have that luxury when our constitutional republic and liberty is hanging by a thread in the balance. That's why we do hot takes like this. That's why we do Legal AF at the intersection of law, politics, and justice, to bring it to you, to call out justices that are conflicted, to call out Donald Trump when he takes inconsistent positions in briefs, hoping nobody will notice. We notice. Jack Smith notices, prosecutors notices, attorney generals notice, and judges notice, and the public at large who's going to make up that jury notice. And we're going to help bring it to their attention one place on the MeidasTouch Network. This is the only place exclusively. Don't turn that dial, as they used to say. Stay right here. Help them get to 2 million. They're about 80,000 people away from turning the odometer over to 2 million free subscribers. Help them get there. This is the network you've been waiting for. And without you, we're nothing. It's an independent, a grassroots social media platform devoted to this kind of thinking, this kind of analysis. We don't blow smoke or sunshine, especially when it comes to the law and politics. So follow us on Wednesdays and Saturdays at 8 p.m. Eastern Time on a show we call Legal AF, and then on hot takes like this one about every day, if not every hour, at that same intersection, law, politics, and justice. Give me a thumbs up if you like what we're doing here. Helps keep me on the air. Until my next hot take, till my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.